Justice Ireland.
Okay,
Oh,
yes.
excuse me.
Please begin, yes.
Thank you, Your Honor. Chief Justice Ireland, members of the Supreme Judicial Court, Paul F. Ware, and with me Kevin Martin on behalf of Lorillard Tobacco Company. This court in Hagelin recognized that cigarettes are a lawful product and also recognized that the law in Massachusetts with respect to breach of warranty is consistent with the restatement second. But the trial judge below in this case misunderstood the Hagelin decision to hold that all cigarettes are unreasonably dangerous as a matter of law. I want to draw the court's attention to 4 legal errors this morning, which, if accepted by this court, would position the court and the Commonwealth of Massachusetts well outside any other jurisdiction in the United States as regards basic principles of tort law. First, in misunderstanding Hagelin, the court failed to adhere to the 2 key elements of breach of warranty law. That is, a defect which made the product, that is Newport cigarettes, more dangerous than consumers expected, as opposed to a cigarette which simply had inherent characteristics acceptable to consumers.
Do you think that there is any, is it your argument that essentially because cigarettes have nicotine and tar and those are necessary to the functioning of a cigarette and to recognize it as consumers know it, that it is impossible to prove products liability without having, as the restatement comment I says, marijuana or some other foreign product in it?
I am not arguing that no cigarette could ever have a defect, no. I am arguing that under this court's decision in Coulter and Ulof and the restatement second and Johnson Insulation, that 2 tests have to be met. First of all, there must be a defect of some kind, something which separates Newport cigarettes from all other cigarettes. In other words, what was it that was different about Newports in terms of their danger, and what was it that wasn't expected by consumers? That test must be satisfied. Secondly, there must be a safer alternative design, something which reduces risk, but does not, in the words of Ulof and Coulter, so harm the product that consumers don't want it. And that's this case.
With respect to the first point about it's got to be, well, the language you use, a unique defect, correct? That's how you describe it.
Well, I don't know that it has to be unique. I know that word has been used in
your brief a lot.
Yes. I would say it has to be distinctive. It has to be something different than all other cigarettes.
Okay, so if there's evidence that Lorillard's scientists and corporate functionaries are spending lots of time working on how to increase the level of nicotine to increase the addictive quality of the cigarette, whose burden is it to show that everybody does that? I mean, why isn't that make that distinctive, that you've got nicotine and tar, but there's evidence that they are working hard at trying to find a threshold and going above it so that they can increase the addictive qualities of the cigarette?
First of all, Your Honor, it remains the plaintiff's burden to show something distinctive about Newport. And if that involves showing something different in terms of its nicotine content, so be it. It is the plaintiff's burden. In this case, both the plaintiff's experts who spoke to the issue said that smokers smoke for nicotine, that nicotine was essential. Judge Fahey herself finds that nicotine is what smokers smoke for.
But then there's levels of nicotine. I guess that's my point.
There are levels of nicotine, Your Honor, but all cigarettes have those levels. Nothing was proved as unique to Newport.
Well, I don't know the answer to this, but let me just ask you this. In Engel, okay, let's just take Engel. I'm not talking now about offensive collateral estoppel, but just Engel. There's liability there, which was affirmed, and put away the class action aspects of it. What was the proof in that case? That each of those defendant cigarette makers had a unique kind of defect?
Well, most of those cases, Your Honor, are fraud and misrepresentation cases. this argument that the tobacco companies.
There was a products liability aspect to that case.
There was a products liability aspect to that, Your Honor. But for the most part, those are fraud and representation cases. And in the end, most of those cases retried as individual cases have been lost by the plaintiffs. But the fraud and misrepresentation count one here, was dismissed on summary judgment. I think the point is, it remains in Massachusetts the law. And in fact, this is consistent with the restatement second, with this court's jurisprudence in Johnson Insulation, and importantly, the restatement third. Plaintiff must prove a defect. That defect must have made the product unreasonably dangerous, that is, more dangerous or dangerous to an extent beyond what consumers expected. That's the words of the restatement second. And the other element plaintiffs must prove is a safer alternative design. That is, a design, in the words of Coulter and Uloth, that does not do such harm to the product, such as removing nicotine so that consumers won't want the product, that it isn't, in effect, a real alternative.
Now, what must a plaintiff prove in order to show that a particular cigarette is more dangerous than what the consumer had anticipated? Does it have to be a different kind of cancer, a different kind of disease?
No.
What is that?
I think, Your Honor, it would be sufficient to prove that the constituents of a particular product were more likely to cause injury than some other constituents of a product. But the problem in this case is plaintiffs have not distinguished Newport in any way from a spectrum of cigarettes sold by every company in the United States. So there is no defect that's specific here. The closest the plaintiff...
Can I just focus, the aspect of the evidence that focused on trying to target young people with menthol cigarettes, and so that and to the extent that that supports the argument that it's more addicting over the long run if you become addicted sooner because of brain changes. Does that weigh in to that?
Well, two observations, Your Honor. First of all, with respect to design defect or failure to warn, the test is an objective one. What would the ordinary consumer understand? With respect to the negligence counts here, there's an utter failure of proof of causation in this case. Plaintiff's expert, Dr. Cummings, testified that the samples, for example, the early smoking of these cigarettes was probably not a cause of addiction. Moreover, this plaintiff, by her own testimony, quit smoking for periods of 5 months on at least 2 occasions, for some months on other occasions, and resumed as an adult, not because of addiction, but for social reasons.
Well, there were some conflicting evidence about that, but so you're focusing on the objective consumer?
Well, certainly for design defect and failure to warn, the issue would be the ordinary consumer. I mean, that is the test under the restatement. That is the test under Johnson Insulation, which is the key case in this court.
And what would that expectation be for that ordinary objective consumer in this case?
The test is whether or not the ordinary consumer would have understood, or whether the characteristics of the cigarette, such as Newport, whether the cigarette would have been dangerous to an extent not expected by the ordinary consumer. After all, this is a bargain. This is a bargain between consumers and the law, if you will. As long as the consumer understands what the consumer is getting, and as long as the product is not more dangerous than consumers expect, then the law permits dangerous products to be sold.
What if the consumer is a child?
Again, Your Honor, with respect to design defect and failure to warn, the test is objective and goes to the ordinary consumer. It's not specific to the plaintiff. With respect to the negligence counts, there's simply no proof of causation here, because plaintiff's expert testified that this plaintiff was probably not addicted by virtue of any sampling when she was a youth. Much of the evidence later on with respect to youth marketing, for example, Exhibit 166, which plaintiff relies on in his opening and closing, is a memorandum from 1978 when the plaintiff is 31 years old.
Wasn't there conflicting testimony, though, about whether she was or wasn't addicted? I mean, the fact that the expert testified to that doesn't necessarily carry the day, does it?
I don't think there was conflicting, or if we're talking about when she was young
Yes.
or what caused her addiction, I don't think there's conflicting testimony as to whether the sampling caused that addiction. Certainly at some point, I think we would concede she was probably addicted.
As a minor.
Unclear, Your Honor. It really is unclear when she became addicted.
So your view is that if Newport were to provide cigarettes to children, as long as they provide an amount that is below that which would addict them, it would not generate a cause of action?
I think it might well, Your Honor, but in this case, there is no proof of causation. Plaintiff's expert says no addiction at that age. Plaintiff herself.
I'm sorry, no addiction at that age because the amount that was provided in samples were too few to
Yes,
produce?
were too few.
Okay, but let's assume that, I mean, again, I've not looked at the trial transcript, of course, but if the evidence were that they gave out these free samples, that as a result of it, she tried it and began to take cigarettes and developed a habit, not an addiction, and over the course of time, through samples and through cigarettes that she borrowed or obtained as a child, she became addicted, would Lorillard not bear responsibility for the fact that it started her on a habit which led to an addiction?
No, Your Honor. Course of conduct is not a theory of liability here. It's a contractual theory. We have to go with the evidence in this case with respect to whether or not the sampling itself caused her to become addicted, and the testimony is simply that it did not. But if I may, I need to touch on a couple of other points. The punitive damages in this case was the second substantial error I want to draw the court's attention to because it represents a $100 million error in this case. What I mean by that is by today, the interest component is about $100 million. And yet, no interest should have been awarded for a couple of reasons. First of all, under this court's case in McAvoy Travel, which dealt with multiple damages under Chapter 93A, the court found those multiple damages to be punitive in nature and held that because they're punitive, the principles of interest simply don't apply. It's not a makeup for lost use of funds by a plaintiff, and accordingly, no interest should apply. There's nothing different about the wrongful death statute, and the word pecuniary on which plaintiff relies is the same language as appears in the general interest statute. Let me touch on two other things in the couple of minutes I have. First of all, the voluntary undertaking claim. This, too, was a significant error on the part of the court. The voluntary undertaking claim has been rejected by perhaps a dozen courts across the United States.
Were the dozen courts also involving this Frank State, the 54 Frank Statement?
Yes,
They're exactly the same.
Exactly, Your Honor. The 1954 Frank Statement is a newspaper advertisement. And the question is whether publication of that advertisement somehow created a legal duty to Mrs. Evans, then 7 years old, and a non-smoker. And all of the law across the country, with the exception of Judge Fahey, says it is not. Furthermore, of course, there would have to be proof that that statement somehow caused harm. Let me finally mention the DOJ findings, the so-called DOJ findings. These are, DOJ is United States against Philip Morris. It's a civil RICO case in the District of Columbia, as to which there are many, many findings. In this case, the court committed two very significant errors, which in combination require reversal. First, at trial, Judge Fahey created a fictitious witness in effect. She first urged plaintiff's counsel to seek offensive collateral estoppel, and then counsel resisted and said, no, we're not looking for offensive collateral estoppel. She then said, well, I have another idea. Why don't you ask questions in which you state the findings? We'll call it an expert. And the plaintiff read very damaging findings from the DOJ case in the heart of Lorillard's presentation during the testimony of its key company witness. This in a case in which the company's credibility was at stake. Those findings have to do with marketing, and in effect, counsel said, would it affect your opinion if you understood that after studying Lorillard's marketing practices, Lorillard has falsely determined or denied that its marketing targeted young people? and several other findings like that. This was a fatal legal error because it so contaminated the jury and foreclosed the possibility of Lorillard presenting an objective case on which the jury could make a determination. In her 93A decision, she gave collateral estoppel effect to these findings without any analysis under Park Lane hosiery whether those findings were essential, and without any analysis of the fact that Lorillard had won a number of cases with respect to those very same issues.
I couldn't tell this, but the findings that she actually quotes in her 93A decision, Lorillard is always bracketed, so I tried to find it in the 449Fs. It was impossible. So were those findings basically the defendants?
Yes.
And then she substituted
Yes,
Lorillard for that?
they're really industry findings, yes.
I thought.
But in this case, of course, Lorillard had prevailed in 6 or a dozen cases in which those very same findings were in favor of the
But they were
defendant.
pre-90, weren't some of them? But could I just ask you one other question?
Please.
In terms of your claim about Mrs. Evans indicated at various points that she understood that smoking had a lot of risks and et cetera, that therefore there was, I take it, you take from that the failure to warn doesn't really apply because she understood the risks. Is that your position?
Well, yes. I mean, certainly later on.
Yeah.
Yes, certainly later on as an adult.
But it seems to me, isn't the plaintiff's claim not so much plain failure to warn? It's the disinformation. It's the pattern of repeatedly saying, well, we really don't know if there's any problem with cigarettes or not over the years. So that it was an invitation to somebody like Mrs. Evans to not have to bite the bullet and accept that it was as dangerous as it was.
Mrs. Evans testifies unequivocally that she was unaware of things like the Frank statement, was unaware of the 1994 congressional testimony, that as to all cigarette advertising, she regarded it as propaganda. So again, in this particular case, there's simply no proof that she relied on any of that. Secondly, much of what you're talking about would go to fraud and misrepresentation. I mean, that's part of the problem with the punitive damages here. While a lot of evidence came in, thrown in over the transom under the guise of reprehensibility, it shouldn't have been, because that evidence was primarily with respect to conduct harmful to others. Here, the plaintiff simply did not indicate in any way that she was affected by those early statements. And Lorillard was granted summary judgment on fraud and misrepresentation on the basis of some of that very evidence.
Mr. Ware, we're going to have to leave it there.
Thank you, Your Honor. Appreciate it.
May I proceed? May it please the Court, my name is Michael Weissman. With me at counsel table is my partner and colleague, Tom Frazzardi. Together with the other signatories to the brief, we represent Willie Evans in his capacity as executor of the estate of his mother, Marie Evans. The judgment of the trial court should be affirmed. Each of the jury's findings and each of the court's separate findings under Chapter 93A are supported by the evidence. There were no errors of law, certainly none that warrant reversal. Lorillard argues in its opening brief and in its reply brief, and again this morning, that to be unreasonably dangerous, a product must pose a risk beyond that which would be contemplated by the ordinary consumer, and goes on to argue that Evans put on no evidence that Newport is more dangerous than expected, and that should end the case. To begin with, it's not true. It's not true that Evans put on no evidence that Newport is not more dangerous than expected.
And when you say that, are you referring to the evidence about manipulating the nicotine levels as well as the menthol?
In part. Evans put on the testimony of Dr. Ferrone. Dr. Ferrone worked in the industry, and he testified that cigarettes, and Newport in particular, is a highly engineered product, that there are 57 or 58 separate engineering decisions that are made with respect to Newport cigarettes, including the level of tar and nicotine. That is a manipulated decision. That is
okay, it's a decision. It's a decision.
Right.
You need evidence that this cigarette was differently engineered than any other cigarette on nicotine and tar.
Exactly, and that
Was there?
And that the levels of tar and nicotine are specifically are decisions that are made by the company.
Okay.
And that they design it to have a particular level that is addictive.
Okay.
And
That's true throughout the industry.
Right, but each manufacturer makes a particular decision about its product, and the evidence was that Lorillard made a decision about its product.
A decision different than any other manufacturer?
Absolutely.
Okay.
Because and with respect to Newport, an additional decision is made, the decision to include menthol, which eases Dr. Ferrone.
Let's leave menthol aside. Let's tar and nicotine. These are the substances. Nicotine being addictive and tar being perhaps carcinogenic. Okay. Different levels here in this cigarette than other cigarettes.
Yes, absolutely. Okay. Each one has a
So
separate.
it's unique.
It's unique.
I mean, it's a trade secret how much they put in there, right?
You bet.
Well, if that's the case, every cigarette is unique.
Every cigarette is.
So the principle is virtually useless.
Well, no, well,
Well, I'd like to hear the lawyer's answer.
Right. Each cigarette is the result of specific design decisions that the manufacturer makes. But there's another component to this.
I don't understand how you cannot tell how much tar and nicotine is in a cigarette.
You have to.
There's no testing that will enable you to tell how much tar and nicotine.
There are publications that tell you how much tar and nicotine is in each.
Okay. And Laura, these Newports are different in what respect? More tar, more nicotine?
It may be, depending on what you're comparing it to.
Okay. Well, is there an industry standard, an FDA standard, any standard on which they are measured against?
But you say standard, each one has its own. Each one will have its own particular level of tar and nicotine, and there are publications that will tell you how much tar and nicotine there is.
But is there some combined threshold below which all cigarettes are considered to be commonly dangerous, and above which some combination of tar and nicotine one must go in order for them to be, quote, unique?
You can get an expert to tell you that below a particular level, the nicotine level the cigarette will not be addictive, yes. And with respect to safer alternative design, there are cigarettes that have been marketed that include a non-addictive level of nicotine. And Dr. Ferrone also testified to that proposition. But with respect to the issue about no evidence that Newport is more dangerous than expected, Marie Evans had no idea that cigarettes were addictive or dangerous when she started smoking at age 13.
But what about when her father died in 1970?
She hadn't the evidence was that she had not had contact with her dad for decades.
But wasn't there evidence that it was a wake-up call to her?
Yes, when she had a heart attack in 1985, not when her dad died in 1970. But Lorillard's argument is inconsistent with this court's 2006 decision in Hagelin. There, the plaintiff stipulated that the plaintiff's decedent at all relevant times was fully aware of the risks of cigarette addiction and lung cancer from smoking and acted unreasonably in starting to smoke cigarettes. If Lorillard were right, that should have been the end of the case, because knowing unreasonable use should be fatal according to Lorillard's argument. But the court in Hagelin said in the circumstances of this case, the Hagelin case, the stipulation was not fatal because cigarettes are a product that cannot be used safely. And what the court said in Hagelin was that where the defendant merchant affirmatively invites the consumer to use a product that cannot safely be used for its ordinary purposes, then public policy demands that the merchant bear the burden of reasonably foreseeable injuries that result from the invitation. If Philip Morris chooses to market an inherently dangerous product, it is at the very least perverse, that was the court's word, perverse, to allow the company to escape liability by showing only that the product was used for its ordinary purpose. It would be perverse in this case to allow Lorillard to escape liability for the reasonably foreseeable injuries caused to Marie Evans and her estate, particularly where she became addicted as a result of giveaways when she was a child. And by the way, there was overwhelming evidence that she became addicted at age 13. 3 different experts, Dr. Cummings, Dr. Benowitz, and even the expert called by Lorillard, Dr. Brady, all testified that she became addicted at age 13. The bulk-
I take it that it was reasonably foreseeable from the company's perspective that someone in your client's position would become addicted and become sick.
Not only was it was expected and intended. In 1964, Lorillard published a memorandum, Exhibit 136, in which it said Newport was marketed and was introduced in 1957. Newport was intended to be a fun cigarette, intended to attract an immature as well as a youthful audience. Who were they talking about? They were talking about America's children, including Marie Evans. And in the 1958 annual report, they said that Newport had been successfully introduced as a result of sampling. They were talking about giving cigarettes to children.
But Mr. Weissman, are you disagreeing with Mr. Ware when he says that your expert testified that Mrs. Evans, did not become addicted as a result of the sampling?
No, in fact, the opposite is the case. Dr. Benowitz testified at page 3058 to 3059 of the transcript that by the time a young person is smoking a cigarette a day, there are already signs of withdrawal symptoms. There's signs of craving. There can be difficulty quitting smoking. So I think that many young people smoking even one cigarette a day every day are addicted. And Ms. Evans testified, and there was no dispute about it, that Newports were always available. The cigarette people were always in the Orchard Park neighborhood, in the playground after school. That happened on more than 50 occasions over a period of years.
So at what point did it become reasonably foreseeable, or actually foreseeable, to your client that she would be ill if she continued to smoke cigarettes?
She testified that when did it become reasonably foreseeable to her?
Yeah. Fully understandable to her that she would become ill if she continued to smoke cigarettes. Very ill.
She testified that she did not realize smoking was bad for her health until 1985.
Okay.
Because she heard conflicting reports. She said it was one of those, there are two sides to every story. Because the tobacco...
And the side that's on the cigarette pack was not persuasive to her.
The first warning appeared in 1966. In 1967, the FTC issued a report saying the warnings are ineffective. What the warning said was that smoking may be hazardous to your health. There's a lot of waffle room in that. May be hazardous to your health. May means it may not be. Hazardous means, well, maybe bad. To your health. Maybe it'll cause you to have a cough. Well, a cough is not so good, but it's not cancer. And the warnings have been toughened over the years precisely because the tobacco industry, Lorillard included, has lobbied Congress to make warnings weak and ineffective.
So in 1985, doctor says no more smoking. This is really bad for
And that's when she had the wake-up call. But she had a wake-up call, but she was already addicted. She was deeply addicted. And the reason she was so deeply addicted is because the nicotine receptors in her brain had been irrevocably altered as a result of the deep addiction. And that's why Lorillard targeted kids. Because when you get kids early, you change their brains deeply and permanently.
Could you talk about the sampling for a minute? I read in one of the briefs that she received about 250 cigarettes from sampling. Do you agree with that?
No, there was no witness testified that she received 250 cigarettes. What Marie Evans said, corroborated by 5 witnesses, her priest and her oncologist, was that there were giveaways in the neighborhood. She said she couldn't we're talking about events 50 years earlier. What she said, well, not quite, 40 years earlier. What she said was that the cigarette people seemed to always be there. She couldn't give a precise number of giveaways. What she remembered was that they seemed to always be there. They were in the playground. She said she thought her best estimate was that there were 50 of them over maybe a 5-year period. Her sister, Leslie Adamson, testified that they always seemed to be there and that they were freely handed them out to children. When I asked her whether they asked for their ages, she said it wasn't about asking about ages. They just handed them out. So it was a presence in the community, like the ice cream truck. But I can't tell you how many, and there was no testimony about how many. We do know that they were handed out 4 to a pack, but how many? No, there was no evidence about how many there were.
If she had this wake-up call in 1985, so your failure to warn obviously goes beyond 1985, right?
The failure to warn claim cuts off in 1970.
Well, yes, but you have altogether?
Because the actual failure to warn is preempted in 1970.
But all the marketing information, I guess it really goes to marketing.
Right, yes.
So in 1985, she has this wake-up call. She understands how dangerous cigarette smoking is to her health. She's had a heart attack. So how do you square that with liability post-1985 for the marketing information?
Because she's deeply addicted, so she makes 50 efforts to quit. So she's simply not able to quit. And the disinformation that she continues to receive, I think the marketing claim is of less import after 1985. But I think what continues to be relevant is that Lorillard continues to market a defective product with manipulated levels of tar and nicotine.
You say manipulated levels, all you mean is distinctive levels. But how different than what is sold as a lawful product?
It is a lawful product, but as I quoted from the Hagelin case, Lorillard ought to bear the consequences of marketing a dangerous and defective product.
But with respect to that, is it the case that unless you can show that Newports are different than inherent cigarettes, you've got a preemption problem because you've got a categorical liability issue there?
It's not, the test under Bach and Hagelin is that there be a safer alternative design. There's no rule in Massachusetts that the product be uniquely defective in the sense that no other product of the type have the same characteristic.
But you've got to get beyond what is inherent in a cigarette, right?
There's nothing inherent in a cigarette about having nicotine of a particular level.
Not at a particular level, but you might say that having nicotine is inherent in a cigarette.
But it's not true. What's true is that
Well, there's arguments about that, right?
Right. But the jury was entitled to conclude that you could manufacture a cigarette with a non-addictive level of
That
nicotine.
anybody's going to smoke?
What?
That anybody is going to smoke?
There was testimony, and Lorillard presented no witness who said no one would smoke it. And Ferrone testified that now Carlton and Cambridge were example of cigarettes that did not suffer from that defect. May I address one other issue before I run out of time?
Sure.
With respect to prejudgment interest on punitive damages, 231 Section 6B does use the words pecuniary damages, but it uses those words in a sentence. And the sentence it uses it in says that prejudgment interest on pecuniary damages are available with respect to personal injuries to the plaintiff, property damage, and consequential damages. The punitive damage portions of a 93A award are none of the above. By contrast, 229 Section 11, the wrongful death statute interest provision, is a unique provision. That provision says in all civil actions for death, prejudgment interest shall be awarded. So it's a very specific provision, captive to 229. It was added in 1913. At that time, the wrongful death statute was a punitive damage statute. That is to say, damages were awarded with reference to the culpability of the defendant. And the legislative purpose, which we've included in the addendum to our brief, states that one of the purposes is to discourage defendants from delay. Here, the trial judge found that Lorillard had engaged in what it called a scorched earth policy that caused delay, precisely the purpose for which prejudgment interest punitive damages was intended. And I would urge the court to affirm the award of prejudgment interest for punitive damages in this case.
Yeah, if I could go back to the issue of defect for one brief moment. Your brother says the analogy here is non-alcoholic beer or non-alcoholic whiskey, and that is not a viable alternative to whiskey or beer, and that nicotine-free cigarettes is not a meaningful alternative to cigarettes. Would you respond to that?
Yes, Your Honor. It's for the jury to decide. It's not a question of law. And the social acceptability of a product is for a jury to decide, and that's why we have the Bach and Hagelin factors, and there are 5 factors. The gravity of the harm posed, the likelihood that harm will occur, the mechanical feasibility of a safer alternative design, and the adverse consequences to the consumer and to the product. Those precise factors were given to the jury by the judge. There's no question that the jury was correctly instructed, and the jury returned its verdict. To take from the jury the opportunity and the obligation to render a verdict based on those legally correct factors would, I think, turn the law on its head. There simply is no authority for the proposition that a jury is not entitled in a warranty case to judge the social acceptability of a product. I think would be inappropriate.
Can I ask you one other question? Because I have not looked at the verdict slip. I apologize. Was there a specific question with respect to a viable alternative?
No, the question was there a breach of the implied warranty of merchantability? The precise, sorry.
Please finish your thought.
Oh, yeah. The precise question was, did defendant Lorillard Tobacco Company breach its implied warranty of merchantability because the Newport cigarettes that it sold to Marie Evans and other consumers were defective and unreasonably dangerous?
I'm sorry, but one more question if I could. Let us assume for the sake of argument that you do not prevail on appeal with regard to each of your claims of liability. Can you prevail on any of them in light of the way that the verdict form treated the issue of causation?
Yes. And the reason for that is that under the Mass Ioneer case, which I grant you is a federal case, the court is entitled to look to the evidence, and the evidence overwhelmingly supported each and every one of the theories of liability. That's my first response. My second response is that there was no objection after the verdict was returned by Lorillard, and under the case law, which Lorillard had an obligation to ask the judge to send it back to the jury for further questions if it felt that there was a concern about that proposition.
All right, counsel, thank you very much.
Thank you, Your Honor.
Your Honor, would it be helpful to the court to have a follow-up letter giving page citations for the testimonies which I referred?
Absolutely. And make sure you give a copy to counsel.